Thank you all very much. Thank you, Tim, and I want to thank the Cato Institute for hosting this event. It's very much appreciated. And thank Judge Kaczynski for joining us, and also Ron Weich. This is a very auspicious occasion. I think I'm going to start with the foreword to the book. It is written by one of our panelists. Judge Kaczynski was kind enough to write that for me, because the issues discussed in the book are fundamental to the fairness of our legal system. The main premise underlying the book is that prosecutors have an ethical and legal and constitutional obligation to disclose evidence that is favorable to the defense. There are legal reasons for it. The Supreme Court held in Brady versus Maryland that it's a constitutional obligation fundamental to due process. And then as a practical matter, prosecutors have all the cards. They are usually their representatives, the agents, the police officers, whoever, are the first people on the scene if there is an immediate crime, or they're the ones who have conducted an investigation into allegations to begin with, or put together all the pieces to charge a crime. They have control of the evidence, they have control of the forensics, they have control of the expert witnesses. And in the cases discussed in the book, they had even more control than that. One of my challenges today will be to talk to you about the book without spoiling any of it for you, because I do want you all to read it. It's written like a legal thriller. I wanted people to be able to read it who are not attorneys, and to find it, and for attorneys also to find it interesting and be held by it, so that you can continue reading all of it. But it is all true. It contains real transcript excerpts. One person recently asked me if I had embellished. He said he was giving me about 10% leeway to embellish for the sake of, making it interesting. And I said, I hate to tell you, I actually toned it down. It's not embellished. So with that in mind, there are a number of things from the book that I will share with you. Robert H. Jackson was one of our great Supreme Court justices, and as Attorney General, he gave a speech on April 1, 1940 that has been enshrined in legal history. He talked about the special role of a federal prosecutor and how important it is for that prosecutor to seek justice and not convictions. He explained that at its best, a prosecutor is one of the most beneficent forces in our society, but at his worst, he is one of the worst, because he has such complete control over what can happen to an individual and such broad discretion. A prosecutor can indict someone, he can have the case processed quietly and secretly, or he can expose it all to the public and humiliate and degrade the person as much as possible through the process. He has control over where the person goes to prison to a large extent. The government likes to say only the Bureau of Prisons decides that, but that's not accurate at all. The prosecutor has a lot of input in that regard, and particularly in the cases discussed in the book, that's true. But yet there's no overriding supervision of prosecutors. You'll see that throughout the book also. Their discretion is virtually unbounded. We like to think of the grand jury system as being one that protects citizens, but it doesn't. Grand juries are virtually a rubber stamp for prosecutors. There's hardly a prosecutor in the country who couldn't get an indictment against a potato out of a grand jury if that's what they wanted to do, or get a case no-billed if that's what they want. So the checks and balances need a serious revision. It's also important for federal judges to pay very close attention to trials. It used to be, I think, at least in my experience, under 10 different United States attorneys in 3 districts across the country over a period of 10 years. It used to be that judges could trust the prosecutors to tell them what the law was and to get the facts straight. No U.S. attorney I ever worked with would have tolerated for 2 seconds the behavior that I saw that caused me to write the book. They all were adamant that we do it right, that we seek justice, that we be fair, and that we carefully exercise our discretion to prosecute only cases that we had all the evidence and were sure the person was guilty. We didn't have time to go, or interest in going to look to find something to pin on someone. That was not our job. No U.S. attorney I ever worked with believed that was our job. And we didn't stack counts of indictments either. We would indict on 1, 2, 3, maybe 4 offenses, assuming we had the evidence racked up to prove all of those beyond a reasonable doubt, with no question in our minds that that was what should happen in the case. And we produced evidence favorable to the defense that the Supreme Court called Brady evidence. That was our job. I have stood in the United States Court of Appeals for the Fifth Circuit and confessed error. When the trial lawyers got something wrong, I would tell the Fifth Circuit, we screwed that up. In fact, if you run through the Westlaw system the word botched, B-O-T-C-H-E-D, you will find a quote in a footnote of a decision by Irving Goldberg where he quotes me as explaining that the DEA agents botched it. I think that's the only time the word appears in Westlaw. And the quote was accurate. I haven't run that search in a while. Maybe I should do it again to see if anybody else has used it, but it's in there. Lots of people want to know why I wrote the book and why I wrote the book now. The answer to the first question is I just could not stand what I had seen. It broke my heart. I have practiced before the Fifth Circuit for more than 30 years. I'm not going to say how many more. My youthful countenance belies that alone, so I'm going to keep that secret. But throughout my practice, I have bragged on and applauded and loved the Fifth Circuit. For it to have been given the repeated chances I gave it to correct the egregious errors in this case and not to get it right was just more than I could stand. And then when the bar associations for these respective lawyers also failed to do anything about it, I felt like I had to speak up. I know I'm not the only lawyer that has seen this kind of injustice. As Judge Kaczynski said in his dissent in the United States versus Olson, there is an epidemic of Brady violations abroad in the land. It is a significant problem. It affects the fundamental fairness of all our proceedings. And if the prosecutors can do what they did to the people discussed in this book who were Merrill Lynch executives, one was a United States senator, others were other business executives, all of whom had led stellar lives to the best of everyone's knowledge, worked in their communities, contributed to charities, done everything right, and believed in the system. To have prosecutors literally make up crimes against them and then be able to push those through the system to conviction and imprisonment, and have federal district judges in Houston and then the Fifth Circuit Court of Appeals not get it right, was simply heartbreaking to me. So that is why I had to write the book. I knew it had to be done by somebody with some credibility. Defendants can tell you about all the injustices they've suffered, and everybody goes, oh, well, you know, he was a convicted felon. So I just felt like it was time that some lawyer stand up and speak out. When I did it, I had no idea what the reception would be. I didn't know whether anybody would pay the slightest bit of attention or not. It turns out people are paying attention, and so I thank each of you for being here to pay that attention to this issue, because it is so important. And there, but for the grace of God, go any one of us. If they can do what they did to these people, as Brendan Sullivan has said to United States Senator Ted Stevens, to 4 Merrill Lynch executives from Wall Street and Houston and Dallas, they can do it to anyone. The reason I wrote it now is because we have given the legal system every chance to work, and it failed to do so. And we also gave the bar associations every chance to do something about it, vis-a-vis the lawyers, and the bar associations did nothing. the Texas bar bounced the grievance we filed against the Texas lawyer like a Super Bowl. I mean, it practically came back by return mail, even though it was written by Bill Hodes, the co-author of the Law of Lawyering and considered one of the top 3 legal ethics experts in the country. It was a 30-page grievance with numerous citations to all the ethical rules and citations to cases, and a definitive explanation of the facts that showed a grievable offense, and the Fifth Circuit opinion, which found that, yes, the prosecutors suppressed evidence favorable to the defense, but it didn't matter. So when the Texas bar bounced that, I actually thought about sending them my law license. I haven't done that because a number of friends urged me to continue practicing, which I'm not sure I can do, but I'm still working on that possibility. And then we also filed with the New York bar against Andrew Weissman and with the DC bar against Catherine Rumler. The DC bar just kind of swept it under the rug. The New York bar, Weissman at the time was General Counsel, Deputy Director of the FBI. So the Department of Justice was defending him against the ethical charges. They kept it for about 14 months, and then without giving us notice, the New York bar punted it to the Office of Professional Responsibility within the Department of Justice. Yes, you heard that right. The Department of Justice was defending Andrew Weissman, and the New York bar punted it to the Department of Justice to decide. Well, you can pretty much figure out how the Department of Justice decided that one. In less than a week, the Office of Professional Responsibility, ironically named within the Department of Justice, now ironically named, dismissed the grievance. So I finally sat down. I said, okay, you've either got to put up or shut up. So I decided to write the book. That's a long explanation of why and when I wrote the book, but that is the fundamental story. The book tells the story of any number of high-profile prosecutions. It tells it as a human story because I also want everyone, including judges, to understand the human toll it takes when prosecutors violate their oath, the Constitution, and the rules of ethics. So there is a very human story that runs throughout the book of my client in particular, some of Ted Stevens, and some of one of the prosecutors, maybe more of the prosecutors than just one. It tells the story of the Arthur Anderson debacle. Most everyone thought Arthur Anderson was horribly guilty. I have to confess that I also, as soon as I started hearing about the Enron disaster, I knew the ramifications on people across the country. Millions of people lost a lot of money. Some people lost all their savings. It was horrible. It was an outrage. And most of us, at least from everything that was reported in the press, assumed that everybody that had anything to do with Enron was guilty. I was one of those. Until I dug into the record of the Arthur Anderson case, when Arthur Anderson asked me to consult when their petition for rehearing was due, no, their reply brief was due in the Fifth Circuit. So they'd already filed their opening brief, but decided to consult additional counsel in the preparation of their reply brief. So that's when I got involved. I think we had 14 or 30 days to get the reply brief filed. The record was massive. Fortunately, Maureen Mahoney at Latham & Watkins was lead counsel because they had a mega staff to divide it up and dive into the mega record at the time. But it didn't take me long to look at it to wonder why the indictment charged what it charged. The actual offense against Anderson was alleged as witness tampering, which requires an element that I couldn't figure out how they were going to prove. And then when I read the jury instructions, the prosecutors had persuaded the district court judge in Houston to alter the pattern jury instructions. Pattern instructions are approved for every circuit for many criminal offenses. If you use the pattern instruction, it's going to be affirmed on appeal. It's already been covered. When judges deviate from the pattern instruction, I mean, that alone raises any number of red flags. There is rarely a reason to do that. But here they persuaded the court to do that. Between the indictment and the jury instructions, I just knew that there was no way Anderson should have been convicted. Turns out, as I dug into it more, the jury was out for 10 days before they returned a verdict of conviction. The company, Arthur Anderson, was destroyed immediately upon indictment. They represented 2,300 publicly traded companies. They had 85,000 employees worldwide. So 85,000 jobs were destroyed. The indictment had to be sealed for a week so the SEC could work behind the scenes to avoid upheaval in the markets. And then once the case went to the Fifth Circuit affirmed without a problem, affirmed the conviction. Finally, the Supreme Court took the case, actually took it pretty quickly by all standards, and reversed it 9-0 because Anderson did not have fair warning that his conduct was criminal. Witness tampering was not the appropriate statute to use, and their conduct was not criminal at the time. And the jury instructions Justice Rehnquist wrote for the unanimous court, he said it was shocking how little culpability the instructions required. They had removed all elements of criminal intent from the jury instructions. The prosecutor primarily responsible for the Arthur Anderson indictment and conviction is now the head of the criminal division of our Department of Justice. Her name is Leslie Caldwell. The co-prosecutor in the Anderson case, Andrew Weissman, became general counsel, deputy director of the FBI. He went on back from his days on the Enron task force after convicting Anderson. They then turned their sights to the Merrill Lynch executives on Wall Street. They wanted to send a message to Wall Street. They viewed New York bankers as wise guys on Wall Street, nothing better than mobsters in suits. Nicer suits, maybe, Brioni suits, whatever. But that was the basic attitude. It was to bring down Merrill Lynch or the Merrill Lynch executives. The destruction of Anderson gave them incredible power when they went to any other organization, because Merrill, for example, knew that if Merrill did not cooperate fully with the prosecution, that Merrill would receive the death penalty that Arthur Anderson had just suffered. So Merrill entered into the most egregious non-prosecution agreement I have ever seen. They agreed that their employees would say nothing publicly that disagreed at all from the task force view of the facts of the case. They agreed that if the task force wanted to interview a single Merrill Lynch employee, a task force attorney could be present. The Department of Justice task force installed an overseer within Merrill Lynch who even reviewed the bills from the attorneys. So we had to be careful how we described what we were working on so as not to let the government know what that was. They named over 100 people as unindicted co-conspirators in the Enron litigation writ large, which meant that everyone had to lawyer up. If their lawyers were smart at all, they insisted that their clients plead the Fifth Amendment, because if you didn't and you talked and you said anything that disagreed with the government's view of the case, you were subject to indictment for perjury and obstruction of justice. They reminded any potential defense witness of that threat daily. Some witnesses got calls during Enron-related trials as many as 3 times a day, reminding them that they faced indictment if they got on the witness stand and testified inconsistent with the government's view of the facts. So the Enron task force prosecutors, Leslie Caldwell, Andrew Weissman, Matthew Friedrich, Catherine Rumler, shut down any access by the Merrill Lynch defendants to any defense witness. In fact, our own Merrill Lynch in-house counsel was threatened with indictment, After she testified in the grand jury, her status was changed from subject to target of the investigation. So even she, when she took the witness stand for the defense, which the lawyers didn't know she was going to do until the last minute, was terrified. Mr. Weissman sat directly in front of her taking notes the entire time she testified. And they didn't give us any of the Brady material or evidence favorable to the defense that the Constitution required we be given. In fact, they told the court repeatedly there was no Brady material in this case. So the 4 Merrill Lynch executives were convicted by the Houston jury. No surprise, their lawyers were like deer in the headlights every time anything happened in the courtroom. The prosecution had witnesses who were cooperating with the prosecution under plea agreements that gave them extraordinary benefits. Their witnesses were the people who had actually stolen money within Enron. Yes, there were definitely some thieves within Enron. They all testified for the government against people who had not taken any money. In fact, as the district court judge sent the Merrill Lynch defendants to prison, he said, "I realize you were just doing your jobs." The Merrill Lynch defendants did not take a penny from anyone. Merrill Lynch made $775,000 on the transaction. The Enron group made $53 million on the transaction. No one lost any money, and there were no material misstatements to the market that would qualify as a securities fraud prosecution. So instead, they indicted the Merrill defendants under the honest services theory of fraud, which alleged that the Merrill Lynch defendants had conspired with Andrew Fastow, Enron's CFO, to defraud Enron of Fastow's honest services. Yes, that would be completely laughable were it not for the fact that 4 Merrill Lynch executives could not get that indictment dismissed. Did they take any money or property from anyone? No, that is a traditional fraud. In fact, fraud means basically stealing. It really falls under one of the 10 commandments, but it's gotten more complicated than that. And the indictment was something I'd never seen before. I did extensive research on it. I could not find a single case in the country from any state or federal court that served as precedent for making the conduct alleged in this case a criminal offense, much less a federal criminal offense. There wasn't one. No problem. Send them on off to prison. Motions to dismiss the indictment for failure to state an offense denied. Requests for bill of particulars to tell us more about what the crime is we're supposed to have committed denied. When the Fifth Circuit got our request for bail pending appeal, the government argued that there was no substantial issue for appeal. Never mind, everything was wrong in the case from the indictment through the jury instructions also. In fact, I've never seen so many issues in a criminal case as existed in the Merrill Lynch Enron case. It was going to be hard to condense that into something, 50 to 100 pages for the Fifth Circuit to decide. Usually in a criminal case, you're lucky if there are 1 or 2 good issues that might warrant reversal. I mean, we had so many in this case, we couldn't begin to brief them all. The Fifth Circuit denied bail pending appeal. The district judge had denied bail pending appeal. So the Merrill Lynch executives had to report to prison and voluntarily surrendered. The judge did allow them to go to the prison themselves, to drive themselves to the prison, as opposed to having them hauled from the courtroom in chains that day, which is what the government asked for, while it also asked for 24 years in prison for them. He gave them 3 to 4 years each and allowed them to voluntarily report. All bail pending appeal motions were denied, even bail. I even sought rehearing because I couldn't believe the Fifth Circuit wasn't going to grant them bail pending appeal, but they denied rehearing also. 6 years later, fast forward, the Ted Stevens case has come along. Judge Emmett Sullivan, very different from the judge we had in the Merrill Lynch Enron case, actually questioned the government when it said there was no Brady. He started requiring them to produce different parts of their investigatory materials and grand jury transcripts and FBI reports of witness statements. And each time they had to produce something, it showed, we should have been given that before. This is favorable to the defense, to the point that Emmett Sullivan made it clear he was going to dismiss the indictment against Ted Stevens. At that point, we had a new attorney general. His name was Eric Holder, and he said he was going to clean up the Department of Justice. So he came in, I think it was about 6 weeks after he was appointed, he came in and dismissed the indictment against Senator Stevens in the interest of justice. I thought, hallelujah, we're going to make some real progress here. Now would be a good time for us to go talk to the Department of Justice and let them know what all has come to light in our case, because we'd finally gotten the notes of thousands of hours of interviews of Andrew Fastow. And he had said there was actually no crime in the Merrill Lynch case either. Even he had agreed that there was no guarantee from Enron that would have made the transaction illegal, the entire thing that the government's case was premised on. He said that didn't happen. They had proved their case only by using the hearsay testimony of Fastow's subordinates. And there was even one Fastow note that explained that he had said one thing to his subordinates and another thing to the folks at Merrill Lynch, just like our defendants had said. We only knew what he had told us in a 5-minute phone conversation. So we thought that was rather significant development. He was the government's star witness against Skilling and Lay, and he was supposedly the guarantor that had made this transaction illegal from the get-go. We got nowhere with that either. We did come talk to the Department of Justice. We were met with bristling hostility, and nobody ever responded to our allegations on the merits. So we're back in the district court. The Fifth Circuit finally reversed the convictions after my client had spent a year in prison. They reversed 12 out of 14 counts of conviction against all the Merrill defendants. They acquitted young Bill Fuse, 32-year-old assistant in Merrill Lynch, who had participated in the deal, acquitted him completely. He had served 8 months in a maximum security transfer facility in Oklahoma, 600 miles from his young family. Our other defendants were not given light duty either. None of them were in prison camps, which I assure you, most are not anything like you would think of a camp as being. They were at least in a higher level security than that. With each level of prison security, frankly, comes additional threats to your own personal safety, because it's the least violent criminals that are in the lowest security facilities and the more violent as you go up the ladder. My client shared a cell with 13 people for the first part of his sentence. One of those people was set on fire in the middle of the night as he slept in his bunk. There are other prison stories that are not in the book that I won't use time on today, but there was a lot that they had to deal with. Fortunately, my client came out fairly well. He is a very affable guy. There's a very poignant story in the book of some things that happened in his life before he went to prison that basically left him with an attitude of gratitude. So he went to prison with the idea of helping other people, teaching people to read, which he did, teaching other inmates how to understand personal finances. He even had his wife send him materials to explain to them how to open a bank account when they got out, how to manage basic household needs and budgeting, things like that. He said that the prison system itself is a farce when it comes to any sort of rehabilitation or education for people. And there's another story, another heartwarming story from his prison that I will leave to your reading in the book also. After they were released from prison and after Judge Sullivan had dismissed the Stevens indictment, a third team of prosecutors finally produced to us evidence that accidentally they didn't really know. They gave me a disc. They didn't know what was on the disc. I mean, they knew that there were documents on the disc, obviously, but they didn't realize the significance of those documents. They gave me a disc that contained yellow highlighting by the original prosecutors of evidence that was favorable to the defense, that they had personally identified as favorable to the defense before the first trial. And they had omitted the keywords and information from that when they gave us a very limited summary of what the actual participants in the transaction had said. One of the statements was just flat out false and misleading in the summary that Catherine Rumler, who became chief White House counsel and only left recently, had signed. She had said that Jeff McMahon, who was treasurer of Enron at the time, had also given a guarantee to the Merrill Lynch defendants, and that he had said he did not recall in the little 4-line summary that they gave us of his statements. Turns out there were multiple pages of his statements to multiple federal agents that consistently said McMahon said there was no guarantee, and that McMahon also said he was participating in the Fastow phone call that was so crucial to the case, and that Fastow did not give a guarantee either. So here we had evidence that both purported guarantors, the only alleged crime in the case, both alleged guarantors who despised each other, agreed long ago, before the case was even indicted, that there was never a guarantee made to the Merrill Lynch executives in this case. So 4 Merrill Lynch executives spent a year in prison on an indictment that made up a crime, while the prosecutors had yellow highlighted and hid the evidence from the firsthand participants that said there was no criminal activity in this case at all. And those prosecutors became chief White House counsel, general counsel, deputy director of the FBI. Matthew Friedrich became the acting attorney general for the criminal division under the prior administration, who rushed to indict Senator Ted Stevens and unseated the longest-serving Republican in the United States Senate, only to have that indictment dismissed after Stevens had lost his Senate seat for the same kind of withholding evidence that happened in the Merrill Lynch Enron case. What can we do about this? The good news is there are things that can be done, and I will run through them quickly. I try to remind everyone as I speak on radio, we even have to remind ourselves that there is a presumption of innocence. Everyone is entitled to a presumption of innocence. We all think that once somebody is indicted, of course they did it. A grand jury found probable cause to believe they did it. We just think that somebody indicted, they've got to be guilty. We've got to remind ourselves. I have to remind myself, everyone is entitled to the presumption of innocence, and the government must be held to its burden of proof to prove guilt beyond a reasonable doubt by competent evidence, and they must be held accountable when they do not produce evidence favorable to the defense. So what can we do in that regard? Judges can enter what's called Brady compliance orders, requiring the government to produce that evidence on a set schedule so that defendants have it in time to prepare for their defense, which is what the Supreme Court requires. Judges are now starting to do that more often. Judge Emmett Sullivan started doing that after the report of the investigation he required came out. And it was identified that because he had not entered a specific order, the prosecutors could not be prosecuted for contempt. They could have been disbarred, so the bar associations must be commanded to step up and deal with that. I'm hoping that there is a public outcry in response to the book to urge bar associations to be more responsible. And I know that there is going to be legislation introduced soon called the Prosecutorial Integrity Act that should receive bipartisan support. There was an effort upon the publication of the report on the Stevens investigation that Judge Sullivan had ordered, a bipartisan effort started by Senator Lisa Murkowski from Alaska to introduce the Fairness and Disclosure of Evidence Act. It received support across the board. The ACLU, the National Chamber of Commerce, the National Association of Defense Lawyers, the American Bar Association, every state bar association I read about, everyone, every major legal organization in the country supported the Fairness and Disclosure of Evidence Act. The only group that I know of that opposed it were the federal prosecutors and our now ironically named Department of Justice. Yes. So there's going to be an effort to introduce the Prosecutorial Integrity Act, which carries many of the same requirements of production on the government and attaches penalties for their failure to produce that the Fairness and Disclosure of Evidence Act would require. So I'm going to urge everyone to support that legislation. And that means really, getting more active about contacting your congressmen and senators and urging them to do something about it. And if judges will start entering Brady compliance orders and start reversing criminal convictions, which I guess is what it's going to take to get their attention, referring things to the bar associations with a letter just demanding action on it, and citizens start serving on juries with an idea of a single juror can stop an unjust criminal conviction. And you can tell if the judge is running a railroad in his courtroom or not. Some do run railroads. You'll see the juxtaposition of Judge Ewing Werlein in Houston with Judge Emmett Sullivan in the Stevens case in the book, and it is very distinct and unmistakable, the difference two judicial attitudes can make. And then we have judges like Judge Kaczynski, who is willing to reverse a criminal conviction and hold the government accountable for its conduct. It's all about our participation, fundamental fairness, and holding prosecutors accountable for their misconduct. It wouldn't take long to clean up the system if everyone did their part. Thank you.
Okay, thank you, Sydney. We're now going to turn to our guest commentators, and our first commentator is also well qualified to address the subject of prosecutorial misconduct because over the course of his career, he has served in the executive branch, the legislative branch, private practice, and now academia. He's presently the Dean of the University of Baltimore School of Law. Before that, he was appointed by President Obama to a high-ranking position within the Department of Justice. He served as the Assistant Attorney General